All rise. The Honorables, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the North Carolina Court of Appeals. I'm Judge Allegra Collins. To my right is Judge Tom Murray. To my left is Judge Chris Freeman. We welcome you for one oral argument today. We thank our clerk, Dina McGessie, and our marshal officer, Salou. Thank you for being here. We have one case. It is 24785 CKE Properties versus Sodoma Law. Counsel, are you ready? You may proceed.
May it please the court. I'm Thomas Bumgardner, and along with my co-counsel Richard Johnson, we represent CKE Properties, the plaintiff appellant in this case. I will be addressing the claims and defenses against the entities identified in the briefs as the Sodoma defendants and the sheriff defendants. Mr. Johnson will be addressing the claims and defenses against Bank America. Today we are faced with the question of whether North Carolina law allows a lawyer to act on behalf of a deceased client without authority from a probate court, commit fraud, falsify court documents, violate the rules of professional conduct, utilize the sheriff to seize the assets of a limited liability company from a private bank, all of course occurring without ever having sued the innocent party or obtained a money judgment. The Mecklenburg Superior Court says the North Carolina law does not provide a remedy for the innocent party. According to the Superior Court, these defendants are entitled to some degrees of immunity, meaning they can do whatever they want, they can take whatever they want, and there's nothing that the innocent party can do about it. But if that's true for CKE Properties, that's true for every person in this room. It's a good thing that's never been the law in our state, and it most certainly should not be the law today. The judgment of the Superior Court dismissing all claims in this case should be reversed for two primary reasons. First, the face of the amended complaint states valid causes of action against each defendant. Second, the face of the amended complaint does not reveal an insurmountable affirmative defense that is sufficient for a motion to dismiss. Before I proceed with my substantive claims, I would like to draw the court's attention to three crucial facts. First, CKE Properties have never been sued by anyone. CKE Properties has not been named in a complaint or issued a summons. There has never been a judgment or order directing the payment of money issued against CKE Properties.
So can you speak to the underlying equitable distribution order that does allow, or seemingly allow, somebody to seize property out of the bank accounts of CKE?
Yes, Your Honor, and that was the second fact I'd like to bring and draw the court's attention to. First, there has never been a final judgment entered in the underlying domestic litigation involving one of the LLC's members, Andrea Kirby. The North Carolina Supreme Court reversed and vacated the original equitable distribution judgment in June of 2019. This court, in a unanimous opinion written by Judge Murphy, reversed the amended equitable distribution judgment in June of 2023. And Judge Murphy's opinion was quite clear. The reason for reversal was because the trial court was not authorized to convert a distributive award to a money judgment. Judge Murphy in this Court of Appeals vacated and reversed that amended judgment. Finally, in August of 23, this court vacated a temporary restraining order that prevented Andrea Kirby only from disposing of certain personal property in those accounts. So there has never been a final judgment entered in the equitable distribution case as to even Andrea Kirby. And so a vacated judgment, of course, is no judgment at all. And without a lawful judgment, there cannot be a lawful execution. The third important fact that I want to draw the court's attention to is that William Crowell died in April of 2022. All of the conduct that is identified in the record occurred after his death, and it was done without lawful authority from a probate court. There were no letters of administration issued. There were no letters testamentary issued authorizing anyone to act on his behalf, whether it be in the unfinished equitable distribution case or pursuing these unlawfully issued executions. And without a client, a lawyer has no authority to act on behalf of anyone. And so with those facts, this court's analysis should begin and end with the Supreme Court's emphatic holding in Micah versus Penland, which authorized a cause of action for wrongful execution and seizure against all of these defendants, no matter their status as a lawyer, a client, a law firm, a sheriff, a deputy, or a bank. And the Supreme Court's instruction was quite clear. The Supreme Court tells us that all persons who have anything to do with the wrongful issuance or levy of an execution, including persons who direct, procure, or assist in the commission of the wrongful act by the officer, even a stranger or a non-party to the suit, are liable to the persons injured thereby. Under Micah, all persons are equally liable to the plaintiff for the injuries committed.
Can you point me to the record where the order is that is essentially that's on appeal?
Yes, Your Honor, that order particularly begins, I don't have the exact page site, but there are three separate orders.
I'm going to be clearer than that. The underlying order that is on appeal, is there an underlying order that's on appeal?
Yes, Your Honor, there are three separate orders.
Okay, and where is that in the record? Sorry, can you tell me?
Yes, Your Honor, the orders on appeal, there are three separate orders that come.
Sorry, I'm not talking about those. I'm actually talking about in the equitable distribution.
The equitable distribution orders are in the record on appeal.
Yeah.
They have been certified by the clerk as being true and accurate.
Mm-hmm.
That would include the original equitable distribution judgment that was reversed by the Supreme Court. That would include the amended judgment reversed by this court, and it would also include the temporary restraining orders that were also reversed by this court. And I think it's really important, too, since Your Honor was asking about information in the record, I want to draw the court's attention to the writs that were issued in this case. There was one writ issued in October of 22, and there was a subsequent writ issued in February of 23. Again, all after Mr. Crow had died and no letters of administration issued for any authority. It's important to note that those writs identify the plaintiff as being William Crowell and the defendant being Andrea Crowell. Well, those are the parties to the domestic litigation, but their roles are reversed.
And when I look at those orders, it seems to indicate that Andrea Crowell's money is in the accounts of CKE. So there does seem to be some overlap, or at least I didn't see any piercing of the veil type language, but it seems to me that that's how those orders read, which is why they can go there.
And that was the point I was going to make, Your Honor. On the face of the writ, none of the accounts are identified. On the face of the writ, CKE Properties isn't mentioned anywhere. The only place that CKE Properties and its assets is mentioned is in an Exhibit A. Exhibit A was attached to the sheriff defendant's motion to dismiss. However, the certified copy of the court file does not include the Exhibit A as part of the writ. We objected to the introduction of that document at the hearing because on a motion to dismiss, the court's analysis is reviewing the facts in the amended complaint in the light most favorable to the plaintiff. So this Exhibit A was never part of the writ. And how do we know that? We provided the certified copy of the file in the record. The Exhibit A does not have a file stamp on it. The Exhibit A is not endorsed by the clerk. So a question that we have is, where did it come from? And certainly that should be room for discovery as to how the sheriff got this Exhibit A and how she then went about in seizing the assets of a party who was never mentioned on the face of the writ. And that's important for two reasons with respect to the sheriff defendants. First, the Superior Court dismisses the claims with dicta from Thomas v. Sellers. The Superior Court's opinion is that the sheriff has no duty to look beyond the face of the writ. Well, Thomas v. Sellers, of course, was a malicious prosecution case, not a wrongful execution and seizure case. And the court goes to say, if the sheriff follows the face of the writ, it's a defense to maliciousness. It is not a defense to conversion. It is not a defense to negligence. In fact, in this case, the writ is ambiguous. And so the sheriff didn't follow the face of the writ at all. The sheriff didn't seize the property of Andrea Crowell. The sheriff didn't seize the property of William Crowell. It took a third unauthorized approach by taking the assets of a party that had never been sued and for which no judgment had ever been entered. This court's analysis in Gallimore v. Sink is all the court needs today to reverse the claims against the sheriff defendants. Gallimore v. Sink quite clearly gives us two things. It gives us the standard for a 12b6 review, and it also confirms that sheriffs in North Carolina are liable for conversion. The issues of whether the sheriff was authorized to act, good faith compliance, all those things are not relevant to a 12b6 motion to dismiss. That's all the court needs to resolve the claims in this case against the sheriff, in addition to the Micah precedent, which tells us all persons are equally liable. The sheriff defendants, though, have raised some defenses, and the Superior Court includes those defenses in the order dismissing the claims based upon a combination of governmental immunity and public official immunity. In this case, looking at the facts of the amended complaint, we have overcome both. First, as to governmental immunity, we have included an express allegation that the sheriffs have purchased liability insurance and thereby waived any immunities that they may have under the governmental immunity. That's North Carolina General Statute 153A-485. That's paragraph 18 of the amended complaint. That's all that we need to surpass the governmental immunity argument at this stage. Secondly, we have joined as a defendant in the case Platte River Insurance Company. Platte River is the bondholder for the Sheriff McFadden. We have included a statutory cause of action in our complaint, specifically at paragraph 11, where we have alleged General Statute 58-76-5, which confirms that all sheriffs are liable for neglect, mismanagement, or injury to the plaintiff through their statutory bonds. So we have included two statutory waivers of governmental immunity in this case. With respect to public official immunity applies only to individual capacity claims against Kimberly Williams. Public official immunity is not available where the individual acts maliciously or outside the scope of their employment responsibilities. In this case, we have alleged a claim of conversion. And as this court told us just recently in 2024, Bates versus Charlotte Mecklenburg, where there is a claim for conversion, there is no need to allege anything in addition. The tort of conversion includes the element of maliciousness in it. And so under Bates versus Charlotte Mecklenburg, again, just last year, this court said the element or the claim of conversion is enough to overcome the defense of public official immunity. But the facts that we've alleged here are particularly egregious and show maliciousness on the part of all parties involved. And to be clear what these facts are, again, number one, no judgment ever issued. CKE was never sued. The sheriff didn't follow the face of the writ and went beyond what she was authorized to do. And under those circumstances, that is maliciousness. That is enough to leave the individual claims against Kimberly Williams at this stage. But we've also alleged she acted outside the scope of her employment. And the way that we did that is that we've expressly alleged, page 70 of the record, that she didn't follow the policies and rules and procedures voluntarily implemented by the Sheriff's Department in carrying out these executions. Whether or not that's true.
There was no stay in place, was there, during the pendency of this appeal?
No, Your Honor.
Okay.
No stay was issued. The only equivalent order to a stay was the one that this court reversed and vacated in August of 23 in the underlying domestic litigation. There's never been a stay in this action.
Had a stay been applied for and granted, would that have avoided all of this?
No, Your Honor, because the stay would have only applied to Andrea Crowell and William Crowell. In this case, we have different parties, different claims, different actions. So a stay, in this case, wouldn't have stopped the Sodoma defendants from putting into motion what they did that caused the sheriff to seize the assets from the bank, and it caused the bank to release them.
So if the argument is that the money in the CKE accounts is actually Ms. Kroll's money, would that have avoided this?
Well, that's not the allegations in the complaint. As we mentioned to the Superior Court, CKE has 3 members to it. That includes Ms. Kroll and her children. Back in 2014, 11 years ago, when she went through domestic litigation, it was all hers. But there's never been an order stopping or staying her ability to modify the partnership agreement or to continue to operate that entity and acquire additional assets. Had that been done, the appropriate procedure, which again was not followed in this case, was for a party with a judgment against an LLC to seek a charging order. A charging order is what's authorized by our Limited Liability Act that allows the court to parse out the individual's interest in the LLC as opposed to the entire LLC. In this case, they just took the entire thing, and they never had a judgment to do so. And they don't say they didn't. In fact, the defendants don't make any effort to tell the court why Micah wasn't controlling on these facts. And I hope they'll tell us today why the Superior Court wasn't bound to follow it. But what they also tell us, or what I hope they also tell us, I hope they'll be forthcoming in admitting the facts of this case were particularly egregious. And that's why the Sodoma defendants don't even challenge the fact that the allegations in the complaint state a claim for fraud, for abusive process, for negligence, for gross negligence, for punitive damages and conspiracy. Instead, they say, you know what? We can do whatever we want because we have immunity. North Carolina law has never given a lawyer, a law firm, or a client to do whatever they want. And it's kind of interesting the way it was framed, page 110 of the record. The Sodoma defendant's motion to dismiss is based upon the claim that they enjoyed absolute immunity to engage in such conduct. And I looked up enjoyed, and it's almost an admission of intent. They desired pleasure doing what they did. They knew it was wrong. They knew it was illegal, and the Superior Court let them get away with it. Does CKE not have the right to bring this case to court and seek a remedy? Micah says it absolutely does. With respect, though, to the absolute immunity claim, again, there are 2 different types of immunity. The first attempt by Sodoma was that they had absolute immunity. Well, absolute immunity, of course, is given to judges, given to legislatures, it's given to the clerk of court, it's given to magistrates. It's never been given to a lawyer or client or a law firm. And so at the hearing, they switched it up on us. They said, this time we're entitled to absolute privilege. Well, absolute privilege is a defense to a defamation action for statements made in the course of a judicial proceeding. To be clear, we're not suing them for defamation. That's a red herring. We're suing them for what they did. And so to confirm the conduct at issue in this case is exactly why they don't have immunity. Number 1, falsifying court documents, representing a client without legal authority to do so, violating the rules of professional conduct, using a sheriff to seize the assets of a party it had never sued, falsifying an execution. All of this occurs 6 years after the judicial proceeding. It wasn't done by asking Ms. Williams on the stand at the ED case what her thoughts about equitable distribution should be. Bank of America wasn't a party to that case. None of the witnesses involved in this action took any part in the domestic litigation involving Andrea Kirby and William Crowell. This court's most recent decision, Toping versus Myers, was the most recent rejection of that defense in a case involving out-of-court statements made at a press conference. This court recognized that the privilege to zealously advocate for a client in the courtroom is appropriate only where the interest of justice require it. This court said making statements as part of your litigation at a press conference goes too far. This court narrowly construed the privilege in Toping versus Myers. The construction of the privilege should be narrowly construed in this case. North Carolina law has never again given an attorney, a law firm, or her client immunities for such egregious conduct.
So I just want to ask, on record set page, let me get this, 24, We talk about the fact that plaintiff wife deposits rental income into different CKE accounts, and that plaintiff wife has one CKE account with Bank of America. It seems to me that the trial court found and concluded that her money was going into these accounts, which would seem to me to authorize whoever was going to attach and get that money to go there. Why is that not true?
Because the defense of authorization was never presented to the trial court. The only defense that was presented was absolute immunity. Authorization occurs in essentially two ways. Number one, the individual acts pursuant to the authority of an actual client. Again, no client here, Mr. Crowell, had died. Secondly, authorization occurs with respect to an order authorizing the seizure of those assets. As I mentioned when we started, all orders in Andrea Kirby's domestic litigation have been vacated and reversed. A vacated order or judgment is no judgment at all.
But again, those were vacated and reversed, but there is something pending on appeal with no stay. Am I correct about that?
There's nothing pending currently.
Okay.
And so all that's open is this never-ending domestic litigation that's been going on for 11 years. And the reason that it's probably still going on now is because there's never been an administrator appointed for Mr. Crowell to end the litigation.
Just so you know, you have 9 minutes and 45 seconds. I don't know if
Thank
you can see that.
At this time, I pass the baton to my co-counsel, Mr. Johnson, and ask that the Superior Court's judgment dismissing claims as to the Sodoma defendants and the sheriff defendants be reversed.
Good morning. May it please the court, Richard Johnson. I'm here to argue regarding the defendant, Bank of America, regarding our claims for wrongful execution, conversion, negligence, and gross negligence. As my co-counsel stated, MICA is a controlling case for the wrongful execution. Now, the bank wants to take a position that MICA does not apply to banks for a couple reasons. Well, first they say that MICA facts are different than this because there's a flawed execution. But the execution that Bank of America had, which is page 121 to 128 of the record on appeal, it's attached to their motion to dismiss, did not have that exhibit document attached. So they just had the writ that listed Andrea Crowell, and they went out and, just like MICA, garnished money from an unrelated third party that was not involved in the case. So that argument is flawed. It's the exact same thing where there was an execution and they garnished money from an unrelated party. The other argument they make is that MICA doesn't apply to banks because MICA did not mention a bank being as part of a defendant in the case. Well, MICA says that all parties could be held liable, and anybody. So just because MICA didn't refer to a bank and the facts weren't clear in there, didn't state whether there was a bank account or not, we would argue that still would apply, that MICA controls, all parties are liable. The other point they bring up is that they're saying that if a bank has to investigate a writ of execution and see, it's going to be too onerous. They have to make sure that it's valid, and how are they going to do that? And have a look into it's going to cost money and time. We're just asking, and it's very simple, that the names on the writ, the defendant's name on the writ, matches the bank account. That's all we're asking for as far as their duty of care and their investigation. So we believe MICA controls. They also argue that they complied, again, same argument, that they complied with a writ that was facially valid. And they refer to the Fought versus Branch Banking account, branch banking case, which is a different set of facts. In that case, the correct defendant's bank account was garnished or levied upon, and he filed suit against the bank. And so, of course, the court of appeals said, well, the bank did everything correct because the right person, the right defendant, the monies were garnished. The other argument they have, well, we believe there's a conversion claim. The bank argues that conversion cannot apply to banks because of case law that says, or some case law that says that once your money gets deposited into an account, that money's no longer yours, which probably most people don't know that, kind of, but it's categorized as a loan to the bank. So they say that conversion cannot apply because it's not in possession of the plaintiff. So it's not a taking, lawful taking. But again, they cite WNC Holdings. In that case, talks about this where the money is not the depositor's money, but it also referred to the depositor agreement that was part of that case. And that's the other thing. The bank brings up the contract issues, that there's, that this is controlled by the contract between the bank and Ms. Crowell. But there was, and they talk about a specific agreement, but that's not part of the record. It's not part of the record of motion to dismiss any kind of depositor agreement between Ms. Crowell and the bank.
So is it your contention that there's no marital assets in this Bank of America account for CKE properties?
I would say yes, Your Honor, because now the parties have been separated a long time. There's some rental properties that are controlled by CKE. So as we're aware that the parties have been separated. I wasn't involved in the domestic case, but I think it's almost 10 years. But so now this is all post-marital earnings. So if there's a rental property that money's coming in, then it would not be marital property. Plus, there's two other owners to the LLC. And as my co-counsel brought up, there's a mechanism to get through the limited liability statute of getting a charging order where you can have that member's distributions garnished. So there's a process to get those funds, if they want to get those funds from Andrea Crowell through the LLC. So at this point, I would say there's no marital connection to those at this time. And there are some, as far as with the conversion claim, in there's a State of Jones, North Carolina case where this issue came up in the larceny case, whether or not the deposit funds were under the ownership of the person who deposited the funds. And the court found that there was constructive possession of the funds in that case. And in some other jurisdictions, South Carolina and Oklahoma, some others, talk about if the funds are in, that's not the case if the funds are in a special account. Now, in this case, after the restraining order was entered, Bank of America moved these funds, and they talk about it in their filings, into what's called a suspense account. It just segregated out and put in a certain place. So we would argue that suspense account is a special account, and it's not part of the normal deposits. So there was possession there defined for conversion. We would argue that we met the burden for our complaint for claims of negligence and gross negligence. Bank of America argues that there is no claim for negligence, gross negligence. There's no duty of care created for banks in this situation where there's a deposit. But we would refer to NC Statute 25-4103 that talks about, under the UCC, that any kind of agreement between a bank and a depositor does not absolve the bank of its duty for ordinary care and good faith. So we believe that we did make a legitimate claim for the survivor motion to dismiss against the bank. And the bank, on page 15 of the brief, they cite Reliance Insurance Company versus North Carolina Bank, which the bank was found liable for giving money to the IRS and where they shouldn't have. So we would argue there are claims for negligence. They also refer to the economic loss, but this is a motion to dismiss. We don't have a contract between, there's no contract in the record between our client and the bank. So we respectfully ask that the court reverse the trial court and
I'm going to ask you one question before you sit down. So if someone comes to let's say, cash a check, and the name of the holder of the account, CKE Properties, is not the same name as the check that is supposed to be cashed. Would you honor that?
No, but you're saying that it's a different,
It's a different
yeah.
name.
And Bank of America cites in a brief, they're saying that the cases that we pointed out have to do with the bank can be found negligent for negotiable instruments if they make a mistake there. They're trying to differentiate that from this. So there is case law under the UCC where the bank can be found negligent for that.
Okay.
So, thank you.
May it please the court. I'm Steve Epstein, and it is my privilege to represent Sodoma Law, Amy Simpson, and Elizabeth Temple in this appeal. The three sets of appellees have agreed to divide our time 10 minutes apiece. I don't know if my clock can be set at 10 or if my red light can go on at 10, but...
I'll tell you when 10's up.
Okay, thank you, Your Honor. Your Honors, we're here today because Ms. Andrea Kroll and her attorneys, the same ones sitting here today, took no action to stay the enforcement of a lawful judgment entered by Judge Christy Mann in the Mecklenburg County District Court once they noticed her appeal. At any time, they could have posted a bond to stay the enforcement of that money judgment. That stay would have prevented the issuance of the writs of execution that formed the entire basis of plaintiff's complaint.
How is the stay from Andrea Crowell going to stay somebody taking money on CKE? CKE is not a party. They couldn't have applied for a stay. They couldn't do anything in this case.
Your Honor, the writs of execution are in the case caption. The case caption is Andrea Kroll, William Kroll versus Andrea Kroll. There couldn't have been any further proceedings, including a writ of execution, in this case if a stay had been entered. That answers the question. My friend is absolutely wrong in saying that, no, they still could have gone after CKE. No, they couldn't have. They went after CKE in this case. If this case had been stayed, that would have been the end of the story. They left the judgment unprotected, and anything that Judge Mann said was a viable place to go collect, in this case, was a viable place to go collect.
So is there marital assets within CKE properties?
Of course there is, and that's exactly what Judge Mann's attachment order says. It says that she was squirreling her assets in those accounts, and that's why she froze those accounts in aid of the execution. That's exactly the authority that Judge Mann had to protect the judgment that was entered by her in her court. That was the court in which these proceedings should have occurred, not Superior Court, which is where these attorneys ran when they didn't protect their judgment, as they were certainly entitled to do, and ultimately collection proceedings occurred, as attorneys will do on an unprotected $424,000 judgment. They were simply doing their jobs to collect the monies that their client was owed. That's their jobs. That's what we do as lawyers. When we do our jobs as lawyers, yes, our courts for 70-something years now have made very clear that we can't be sued for doing our jobs as lawyers as long as what we're doing is in the course of judicial proceedings.
Okay, explain to me the status of the equitable distribution litigation. There's been a lot of orders given and a lot of orders reversed, right? And so has there been a final order or judgment in this case?
I don't know that, Your Honor. I'm not involved in the underlying domestic case, so I don't know the answer to that question. I just know what happened to get us to where we are now.
But doesn't it matter whether there was some sort of order that authorized these writs of execution? Because if an order is vacated, then there's nothing upon which this can be issued, or am I wrong?
Your Honor, there's a sequencing issue here.
Okay.
My friend wants to make it seem as if there was never an order in effect that permitted Ms. Simpson and Sodoma Law to do what they did. That is an absolutely untrue statement. The attachment order, which Your Honor did find in the supplement, it's at page 22, the attachment order absolutely allowed execution against all of these bank accounts. That was a live existing order in full force and effect, as was the underlying equitable distribution order. Neither of those had been reversed or vacated at the time of the totality of what is alleged in the complaint. They were still valid judgments of Judge Mann and the Mecklenburg County District Court when 100% of the actions alleged in the complaint occurred. 100% of what my clients did was done pursuant to judgment and an order entered by Judge Mann.
How does the death of your client's client impact this analysis?
Well, Your Honor, we're here on a 12b6. Let's remember that. We take the allegations of the complaint as true. And no matter how many rooftops my friend screams from that Mr. Kroll was dead, what he alleged in the complaint was as follows. What they alleged was, in paragraph 23, William Kroll developed Alzheimer's and was unable to participate in his equitable distribution trial. In his absence, and ostensibly as his power of attorney, defendant Elizabeth Temple authorized and instructed defendants Sodoma and Simpson to pursue his claims. And further, in paragraph 6, they're saying that my lawyer clients had no authority to do anything. That's not what they say. Their allegations are taken as true. Paragraph 6, at all relevant times herein, defendants Sodoma, Simpson, and Temple maintained, at all relevant times, maintained an attorney-client relationship, and defendants Sodoma and or Simpson acted within the course and scope of the attorney-client relationship. They can't have it both ways. They get all of those allegations are accepted as true. That's the 12b6 standard. That defeats everything they said about, well, Mr. Kroll was dead, so there's probate statutes. That's not their complaint. That's their decision to pursue different arguments on appeal, and they're the ones telling us we're swapping horses to get a better amount. And Your Honor, the writs of execution, which they say don't on their face reference CKE, that's not true either. Writ of execution number 1, which was issued in October of 2022, page 28 of the supplement. You've got a very tiny box. It's like a subpoena. So in a subpoena, sometimes you have to add more stuff because there's no room on the AOC form. That's true here. So what this writ says is that the sheriff shall seize the plaintiff's accounts with Bank of America, Fidelity, and Merrill Lynch, more specifically set forth in the attached order of May 9, 2022, which is Judge Mann's attachment order, which specifies by account, including the CKE accounts. So the face of this complaint does, in fact, allege to refer to those very specific accounts, as does the second writ, which was issued in February of 2023. Again, long before this court vacated Judge Mann's orders. All of these things are happening while those orders are in full force and effect, and this one says specifically set forth the Bank of America, Fidelity, and Merrill Lynch accounts more specifically set forth in Exhibit A, which was essentially a summary of what was in Judge Mann's attachment order. So the first one attached Judge Mann's attachment order, which included the specific CKE accounts, and the second one listed them in Exhibit A. So clearly what my clients did all sprung from that May 2022 attachment order entered by Judge Mann.
Did I hear that Exhibit A, there was an allegation that it actually wasn't attached, or did I misunderstand that?
I think there's some confusion about that, Your Honor, but there's an Exhibit A, and there are various references throughout both the record and the supplement to the Exhibit A, which again is just a paraphrase of what was in the attachment order, where Judge Mann did in fact say that Ms. Kroll was squirreling her money. Remember, she owes $424,000 in a money judgment. The fact that this court later said, no, she couldn't do that is beside the point. They're saying what they did was improper, illegal, and they can be personally liable for it. How can they be personally liable for what Judge Mann authorized them to do? It makes no sense. We do rely heavily, Your Honor, on this court's decision in McManaway, fully aware that it's not binding precedent. You could not find a case more dead on point, a losing litigant in the district court pursuing superior court, pursuing superior court claims for personal liability against the attorneys and parties who defeated her, alleging virtually all of the same claims in McManaway as are alleged here. Judge Titus in Orange County dismissed those claims for the same reasons Judge Edie Williams dismissed the plaintiff's claims against my clients here. One, all of the claims asserted arose out of statements or conduct in the course of judicial proceedings. There, it was a child custody case where a baby was basically stolen. The court said that was pretty malicious, but the attorneys and the clients, they still had immunity because it was in the course of judicial proceedings. Remember, malice is not something that makes any difference in this court's absolute immunity, absolute privilege doctrine. And number two, the statements and conduct were sufficiently relevant to the underlying judicial proceeding. Obviously, everything that my clients did to collect upon the lawful judgment entered by Judge Mann through writs of execution was it connected to a judicial proceeding and were relevant to that judicial proceeding. Collection proceedings are judicial proceedings. I think my friend wants to say, no, the case was over. So nothing that happened after that was a judicial proceeding. Then why are all these things filed in court if they're not judicial proceedings? Of course they're judicial proceedings. And finally, 3, the claims in both cases hinged on statements alleged to be false, fraudulent, or misleading. Plaintiff's reply brief tries mightily to squeeze out distinctions between McManaway and this case, yet what they say upon close inspection is 100% the same. The 2 cases are essentially identical. And what this court found in McManaway was that the lawyers and the parties involved were entitled to absolute immunity, no matter how egregious what they did was in relation to a baby, because it all happened in the course of judicial proceedings, and all of the claims were relevant to those judicial proceedings. Thank you, Your Honor.
Thank you.
May it please the court, Sean Perrin for Sheriff Gary McFadden, Deputy Sheriff Kim Williams, and the Sheriff's Surety Platte River Insurance Company. For more than 175 years, 1844, the Welch v. Scott case, it has been black letter law in North Carolina that neither a sheriff nor a deputy has to investigate the validity of a writ or the process. And the reason I would contend to the court is simple, 3 reasons. First is, it's a ministerial responsibility. A sheriff under 162.14 is required, it's mandatory, to serve process. 162.16 deals with orders and judgments. 2, with all due respect to all the wonderful sheriffs across the state, do you really want a sheriff, when serving process, to look at it and decide, you know what, I need to investigate that? And 3, if you did, the judicial system would not run properly. And if you look at plaintiff's complaint, that's exactly what they say we should have done. Investigate the validity of the writ. Records 61 and 63. Sheriff McFadden Williams, quote, failed to conduct any reasonable investigation as to the validity of the execution and or the underlying judgment. Record 71. Williams took no action to confirm the validity of the judgment. And they continue that theme in their principal brief, that is, we should have investigated the validity of that judgment. This court has never recognized it. Again, since 1844, the law has been clear. 1872, State versus Ferguson, the Supreme Court said the state is not bound, the sheriff is not bound to look beyond the process, and he was justified in doing so. 1949, Alexander versus Lindsay, same thing. This court in 2001 in Thomas v. Sellers, in 2002 in Emery versus Pendergraft. Same rule of law. We are not obligated to look beyond the face of an order.
So can I ask what they allege you should have looked beyond for? I put another way, does this writ of execution authorize the sheriff to do what it did?
Yes.
On its face?
Yes, it absolutely does. If you look at Exhibit A, says seize CKE property. Seize CKE's properties at Fidelity, Bank of America, and that's what Kim Williams did. Now I'll say this. If she went out and executed on a different company's assets, that's a problem. That's Micah versus Penland. This is not Micah versus Penland. Deputy Williams attached exactly what the writ said. As Mr. Epstein pointed out, that's exactly what Judge Mann said, and that's what she did in Exhibit A.
For sake of argument, if Exhibit A wasn't attached, would the face of this still be valid?
Yes, I think it would.
Why is that?
And let me start by saying the plaintiff has not objected in their brief to Judge Williams considering that. Number 2, I would say this. The order says, if you look at the writ, taking out Exhibit A, it says seize the properties, and you look at Judge Mann's order, that sort of summarizes what properties need to be taken, what properties need to be attached. I would also say, if you look at the writ, either the clerk's writ 115 record through 117, or the sheriff's record 118 through 120, this is not one of those Moorish nation or sovereign citizen orders that sometimes you see. It's on an AOC form 400. It's got the correct CVV number. It has the parties. It has directed towards the sheriff of Mecklenburg County. It has the principal. It has the interest, date of judgment. It has the debtor waiver here. and it's directed towards the sheriff of Mecklenburg County. If it were directed towards the sheriff of Wake County or Cabarrus County, then I wouldn't be here because Kim Williams would not be able to serve that writ. But the facts are this. This is on an AOC form. It's a writ of execution authorizing her to serve the exact accounts that were listed in the writ. And plaintiff's theory, again, that the sheriff should somehow investigate the validity of a writ is contradicted by North Carolina law. 162-14 says this: every sheriff by himself or his lawful deputies shall execute and make due return of all writs and of the process to him legally issued and directed. And if Kim Williams doesn't serve this writ, what happens? Under 162-15, a party can apply to a court for a show cause order and assess penalties against her. So she's left with two situations. Serve a facially valid writ. Again, this is not handwritten in crayon. It's on an AOC form. Or she can do an investigation, review the 3 or 4 appellate court decisions and say, you know what, I'm not really sure if CKE is a proper party here. But then she runs into the situation, if she doesn't do that, she's subject to penalties under 162-15. She did exactly what the law says she should do: serve the writ. Let me talk briefly, Your Honors, about Micah and Gallimore versus Sink. Those are the 2 cases that plaintiffs rely upon. I would contend those are misplaced for several reasons. I'll start with Micah. 3 reasons why Micah does not apply in this case. First, Micah, a judgment debtor received a judgment against Minerals Processing Company, not Micah. And the sheriff was authorized to seize property of Minerals, not Micah. And the sheriff levied on Micah, not the correct party. Number 1 here, again, the writ authorized Kim Williams to execute on CKE, and that's what she did. And in fact, the plaintiff complains, not that we ignored it, like in Micah, but that she actually complied with it. Number 2, you heard Mr. Bumgardner earlier say there's no valid judgment in this case. Well, Micah, there was not an attack on the underlying judgment. The remedy should be go back to Judge Mann in Mecklenburg County District Court and apply for an order to Judge Mann, not sue everyone here, myself, Sodoma, B of A, in Mecklenburg County Superior Court. 3, Micah did not involve any theory that the writ was invalid, there needed to be an investigation. Again, in Micah, the writ was served wrongly. Here, the writ was served correctly. And I would contend that Gallimore involved a case where a sheriff took someone's gun and gave it over to the SBI without any process. Here, again, there was process. It was a writ that Kim Williams followed. And that's all you need to dismiss all the claims against my clients, because there has been no case ever in North Carolina history which says you, sheriff, need to investigate the validity. You need to find out why this says what it does. And I would contend to the court, there's a reason for that. Because you don't want deputy sheriffs who are required to serve process to look at an order for arrest, and summary ejectment, and say, you know what, I don't think this person lives here. I don't think this person committed that crime. The legal system cannot work that way. And that's why the trial court was correct in dismissing the claims against my clients and asked this court to affirm. If this panel has no further questions, I will turn it over to my colleague from Bank of America.
Real quick, just in case I disagree with you, and we think there is a claim as articulated in the plaintiff's complaint, what's the impact of the insurance? Is that a waiver?
Yeah, and thank you, Judge Murray. We did not move to dismiss this claim based on sovereign immunity. Mr. Bumgarner is correct. The trial court granted us a motion to dismiss on sovereign immunity. That's an official capacity claim against the sheriff. There is a waiver with Platte River. But again, I don't think you need to even get there, because again, there's no duty to do what they said we should have done. But you are correct. And to be fair, Mr. Bumgarner is correct too. There is a waiver. We didn't move for that. But again, we don't need, I think what the case law says is if the decision can be justified by other means, other reasons, then that's enough. But you are correct. The sovereign immunity issue is the trial court was wrong.
Okay, thank you.
I've got one question for you. So if we were to look at this writ, and on its face it says Crowell, and it says in the writ to seize, I don't know, the the bank account of Allegra Collins, and there's no underlying trial court judgment for that. Is that on its face still valid? Can the sheriff still do that, or is that different?
I think in North Carolina, yes, it is. I mean, and again, it goes back to the point, Judge Collins, where, you know, if Kim Williams sees the account of Allegra Collins, she's not required to do an investigation, right? And to figure out, well, what accounts does Judge Collins have? Now, again, I'll say this: if it's not on an AOC form, if it's, you know, not a court of competent jurisdiction, yeah, I think Kim Williams would need to say, plaintiff's attorney, defense attorney, whoever did the writ, what's the issue here? But without that, no, I don't think there's any duty to investigate.
Okay, thank you.
Thank you.
You've got 10 minutes. I don't know if you can see.
Thank you, Your Honor. Dylan Bensinger from McGuire Woods on behalf of Bank of America. May it please the court, Bank of America is involved in this lawsuit in the first place because it received a facially valid writ of execution issued by the Mecklenburg County District Court, served by the sheriff defendants in this case, and it obeyed that writ of execution as it was written. That's it. CKE argues that the bank had some additional obligation to investigate the validity of the writ or simply refused to obey the writ as it was written because there were certain ambiguities or vaguenesses on the face of the writ. And for similar reasons, as Mr. Perrin discussed, that's incorrect for both legal and factual reasons. Starting with the legal reasons, there's absolutely no authority in North Carolina, not in the briefing that CKE provided, not anywhere else in North Carolina law that requires banks to do their own independent evaluation of writs of execution before.
So is there a difference between a writ of execution and, for example, a wire transfer? Because it is hard to get money out of banks, let's say, to close a house, right? And so is there a different standard there? Are there different rules that you're under?
Sure. I think what you may be referring to, Judge Collins, is the UCC provisions that CKE refers to in its briefing. And yes, there are UCC provisions that clearly stand up duties of care with respect to transfers of funds or negotiable instruments or other circumstances. That does not exist with respect to writs of execution in particular. And that's for good reason, because I think the legislature intended for banks to simply comply with facially valid writs of execution. Otherwise, they would be faced with pretty significant cross pressures, right? On the one hand, they could be liable for contempt of court for refusing to obey a writ of execution that appears facially valid, like this one did. And on the other hand, they could be subject to tort liability from account holders who claim that there was no sufficient investigation into what the writ said.
Can you explain to me when you say appears facially valid, what makes this appear facially valid other than it's an actual form? Is it the contents that makes it appear valid?
Sure. The form of it does make it appear valid. If you look at this from the bank's perspective, right, it received this process from the sheriff defendants. Nothing on the face of that process gave the bank any reason to doubt the validity of the writ. There was a court order referenced in the additional instructions for judgment box on that writ, like you've heard already today. And that court order gave clear instructions on which accounts were subject to the writ of execution.
If the court order weren't attached, would you all go look at that court order?
I presume the bank would, but in this
So they
case,
would actually do some investigation?
well, they would look at the court order that the writ of execution references explicitly. Our position is that for purposes of this writ, that's part of the writ. It references the court order specifically. It said, look at the May 9th attachment order. The May 9th attachment order says the writ of execution applies to X, Y, and Z accounts.
So even if it didn't arrive in the same email or in the same package, you all would go and look at the court order?
I presume that's correct, Your Honor, but in this case, even the face of the pleadings make it clear that the bank was in possession of that order at the time the writ was served, because the writ was served in December of 2022 here. But CKE alleges that Bank of America, quote unquote, released certain of the funds subject to the writ in May, which only could have happened if the bank was aware of the language in that May 9th attachment order. So from both a legal and factual perspective, it just is not the case that the attachment order and the writ that referenced it were too vague or unclear for the bank to have obeyed. There's also specific and fatal flaws in each of the three specific claims that CKE brings against the bank. The first is a wrongful seizure and execution claim. CKE brings that claim under Section 230, 1-230. North Carolina case law is crystal clear that 1-230 claims cannot survive if the defendant is not in possession of the funds at issue at the time the complaint was filed. The complaint says right on its face that Bank of America, quote unquote, released the funds in 2022. This complaint was not filed until 2023. That alone is enough to defeat the wrongful seizure and execution claim. There's also, from a more public policy and legislature-facing perspective, the same rules that I've already discussed. Section 1-359 makes it a complete defense for banks to comply with facially valid writs of execution. You heard CKE's attorney say that the Fought case that clarifies that complete defense does not apply because there was some dispute about who the judgment debtor was at the time of execution. Not the case. At the time of the execution in 2022, and again, this is before the appellate courts, this court and the Supreme Court, reversed Judge Mann's decisions in 2023, but in 2022, when this writ was executed, there was no dispute. Andrea Kirby was the judgment debtor, and the court's instructions were clear that the execution extended to her funds in the CKE account. You've also heard a lot about Micah v. Penland today. The bank's position is that that case is distinguishable for the same reasons that the sheriff defendants explained. This is not the case, not a case where the writ was executed against an unrelated third party that had no relation to the underlying proceeding. Here, in contrast, the writ of execution clearly directed the bank to the accounts that the plaintiffs argue were the accounts that were executed against. CKE's next claim is a conversion claim, and CKE counsel is correct that in North Carolina it is crystal clear that when a depositor deposits funds in a bank account, legal ownership of the funds switches from the depositor to the bank. So without ownership of the funds, a conversion claim cannot survive. One of the essential elements of a conversion claim is the plaintiff must have ownership of the property that was allegedly converted. That was not the case here because under that North Carolina doctrine, ownership passed to the bank. You heard CKE's counsel mention the State v. Jones case. That was a larceny case, a criminal case that involved the crime of larceny, not the tort of conversion. Possession is an element of the crime of larceny.
So it would be your cause of action for conversion if the writ of execution was incorrect. Is that what you're saying? Because you possessed that money? It would be converted from the bank?
In theory, I guess there could be a conversion claim issued by the bank on that element, but the second element of conversion is the wrongful deprivation of the property. The bank would also have to prove that. Under these circumstances, that wouldn't be the case for anybody because, as we've been talking about, there was no wrongful deprivation of the property because the writ of execution authorized the bank to do exactly what it did. But back to the Jones case, that involved larceny. Possession, which you heard counsel talk about as an element of larceny, different legal concept than ownership, right? One can have possession of an object without having ownership of it, and that's the difference here. Even if CKE had constructed possession of the accounts in the CKE or the funds in the CKE account, under this crystal clear North Carolina law, under Holloway and Lippe, which we cited, it did not have ownership. The third claim that CKE brings against the bank is negligence. There are two problems with that claim. First, I want to be very clear about the bank's argument with respect to the UCC and duties of care. CKE seems to be understanding the bank's argument to be that under no circumstances can banks have duties of care to any customers ever. That is not our position. The UCC, like I've said, does stand up duties of care that banks owe to customers in certain specific situations. writs of execution and the bank's duty to obey those writs is not one of those duties that the UCC stands up. But let's pretend that it does for a moment. Let's pretend that there are duties of care arising out of the UCC. It's also clear in North Carolina, and this is the Withers case that CKE itself cites, that it is well settled, this is a quote from North Carolina, the economic loss rule prohibits recovery for purely economic loss in tort when a contract, an express warranty, or the Uniform Commercial Code operates to allocate risk. So to the extent they're alleging their negligence claim arises out of a UCC-created duty, that negligence claim runs headlong into the economic loss rule, which bars negligence claims arising out of UCC duties. The economic loss rule also applies to the conversion claim and the wrongful seizure and execution claim. CKE argued that there was no contract in the record here, but as a matter of North Carolina law, under the WNC Holdings case, a contract is created when a depositor deposits funds with the bank. So as a matter of law, there was a contract in this case, regardless of what the record says.
Thank you.
Thank you, Your Honor.
Thank you, counsel.
I was just make 2 brief points on rebuttal. The first is
You
factual.
have 31 seconds.
The first is factual, the second is legal. Factually, the amended complaint alleges the death of William Crowell and the defendant's failure to follow the probate law. That's page 57 of paragraphs 45 and 46 of the amended complaint. Secondly, Mr. Perrin brought up a good point about due process. When the sheriff doesn't follow the order, the sheriff is allowed to go to court after a motion is filed, after an affidavit is submitted, after a hearing is held to explain why the account doesn't match the writ. That's due process. In this case, CKE received no due process, and its assets were taken without lawful authority. The judgment should be reversed.
Thank you. Thank you, counselors. Excellent arguments. Appreciate your time. Please gavel us out.
All rise. Court adjourned.
Good job, guys.
Good job.
Thank you.
You too.
Thank you, likewise. I walked 2 blocks.